Welcome back, everyone. Michael here with Offshore Citizen. Today I wanted to go through a little bit of a myth and some examples to demonstrate this point, which is really significant. And this is the subject of tax residency. Now, I've mentioned in some previous videos, you actually don't necessarily have to be tax resident somewhere, and you don't have to necessarily meet the standards of tax residency in another country in order to be considered non-tax resident in your own country, even though there might be some crossover. And there's some people tend to get caught up in this in a way that's not accurate, okay? This being said, the opposite is also true, which is I'll sometimes hear people say, oh, hey, I'm not gonna spend 183 days there. It's like, you could be really taxable in that situation. And what a lot of people don't seem to recognize is tax residency isn't just a function of time, it's typically a function of fact. It does vary country to country. So in some countries, it's very clearly established. Maybe it's like, hey, listen, if you're out more than 183 days, you're not a tax resident. In other places, like UK, you have an objective set of tests, but it's not quite so simple as just the amount of time, right? Or at least not that threshold of time. That being said, I've mentioned to some people in some other cases that there are a bunch of countries where you can leave the country, physically be gone for like a couple years and still be tax resident in that country. And if you come back, they're gonna tax you on the entire time you're gone. And as an example of that, I figured I was gonna go through with you guys today a bunch of examples from the ATO of their actual examples to demonstrate to you how crazy this is and how this could screw you up and how important it is to plan properly around it, which is why I work with people all the time to make sure, hey, listen, did you properly exit? Do you have a tax treaty protecting you, et cetera, et cetera, et cetera. So anyway, I'm gonna dive into that. I'm gonna explain it to you guys. I'm gonna go through these examples and comment on them a little bit. I hope they're useful for you. Before we do, if you haven't already, please smash the subscribe button, nail the notification bell. Really appreciate your subscription. Give the video a thumbs up if you like it. If you would like help with these things of you're looking at moving abroad, you want to minimize your tax, you're worried about being caught in that tax net, or you're wanting to stay in your country but set up your company abroad, etc. You're dealing with whatever, something with international investing, international business, getting another residency, buying a second citizenship, getting an unofficial citizenship, any of these types of things, please reach out to us. You can book a call with me, calendly.com/Michael-Rosmer, link in the description below, or send us a message through our website, offshorecitizen.net or offshorecapitalist.com. Okay, so we're going to start right at the top of the list. By the way, this is from the ATO website. So the ATO are pretty draconian, right? This is the Australian Tax Office. The truth, though, is that many countries actually are like this. So Canada could have the same thing, a bunch of countries could have the same thing, a bunch of European countries, etc. So I'm using this as an example, but don't think that they're the only ones. They just happen to be one of the better ones at documenting it. So in this particular case, Simon, a new migrant who changed his mind. Facts: Simon migrated from England to Australia with his family on a visa. Shortly after arriving in Sydney, he bought a house and secured a job with an accounting firm. The children went to the local private school while his wife took up various leisure activities similar to those she had been engaged in overseas. Simon still owned an overseas property, which the family lived in before migrating to Australia. 4 months after arriving, the family decided they were unhappy here and returned to England for good. At the time of departure, they were still British citizens. They did not have Australian citizenship, even if they had wanted to be naturalized. Okay, so let's note here, they spent 4 months in the country, not more. They still had a house back in their home country. They weren't citizens there. They were in Australia. They were citizens abroad, right? Do you think that they would be tax residents? So the answer in this particular case is yes, they are considered tax residents, and here's what they say. Although Simon and his family were in Australia for only 4 months, they're considered Australian residents on the basis that they were residing here for the duration of their stay. This is despite the fact that Simon owned a family home overseas during that period. Their intention of residing permanently in Australia was obvious through their actions of obtaining a permanent resident visa, Simon getting a job, the children going to school, the wife engaged in activities that were similar to the previous ones, their purchasing of a home and treating it as such. Although the family was not physically present in Australia for long, they were displaying behavior consistent with residing here from the moment they arrived. These factors allow the family to satisfy the residency test. Therefore, it is not necessary to consider the statutory tests. The fact that citizens all along is irrelevant in arriving at the decision. So the thing that I want to point out about this is a lot of this, when you're dealing with countries that have fact-based residency as opposed to objective-based residency, is the notion of intention, okay? Do you demonstrate the intention to leave permanently? In this case, they were supposedly demonstrating the intention to leave UK permanently and go to Australia permanently. And what are the facts around how you treat it? Like, do you act as though it's your home? And so you see that this is how it went. Well, let's go on to the next example. Emily, teaching in Japan. Emily leaves Australia to work in Japan as a teacher of English. She has a 1-year contract, after which she plans to tour China and other parts of Asia before returning to Australia to resume work here. During her time in Japan, she lives with a family who treat her as one of their own. She rents out her property in Australia during her absence. Emily is single, her parents live interstate, and her brother has moved to France. Okay, so once again, what do we see? We see somebody who's leaving the country, conceivably in this example, for 2 years, right? She's clearly out of the country for more than a year, right? Her home, which she has back in Australia, she rents out, so it's not available to her. So actually, she doesn't have protection under the tax treaty, or the tax treaty is not going to infringe on her in that regard, right? She goes to this other place. She has a long-term contract there. She has a job there. She has these things. Do you think that she would be considered Australian tax resident? So, outcome. Why is Emily considered an Australian resident? Even though Emily is residing in Japan under the domicile test, her domicile is in Australia. A resident who has always lived in Australia would generally retain a domicile here when they are absent overseas, unless they choose to permanently migrate to another country. Her permanent place of abode remains in Australia. So, again, notice how literally not just less than 183 days, like 0 days in the year, and still remained a tax resident, okay? So very, very important to understand how that works. Let's do the next one. Gerhard, a new migrant who hasn't quite left his old country. Gerhard migrated from Sweden to Australia with his family. He had to return to Sweden to see out a performance contract he had 2 years to go. He departed 1 month after arriving and settling the family here. In Sweden, he stayed in the family house that they had been living in before moving to Australia. He also retained the family car so that he could travel around for his work in Sweden. He used to play tennis with the local club in Sweden, and on his return resumed his association with the club. Although he intends to join his family in Australia for good at the end of the contract, he is leaving his options open in case he is able to secure another contract. In the 9 months that he has been back in Sweden, he has only visited his family in Australia once. So, what would you say? Is he an Australian tax resident or a Swedish tax resident? So in this particular case, he is actually a Swedish tax resident. He's not an Australian tax resident. So bottom line of this is these are some examples that somebody would look at and say, man, like what's going on here? So in this one, let's go through the specific tests they used. Okay, so they used what's called the residency, the resides ties. Which is, although he has a residential home in Australia and his family resides here, these factors are not significant enough. He is not physically present in Australia for a considerable period of the income year, and he intends to return to Sweden after a short stay in Australia for the purpose of settling his family. So notice the word intention, right? Very, very important. The residency, the domicile test. He has not conclusively demonstrated that his domicile of choice is Australia. His circumstances indicate that he has a permanent place of abode in Sweden. His intention of joining his family for good after completion of his contract is also not conclusive, as his actions indicate that his absence from Australia is indefinite, and his single visit to Australia in the 9 months adds weight to the conclusion drawn. He was in Australia for only 1 month, so he's less than 183 days, and he does not apply, he doesn't have, there's something called superannuation, and the rules around that doesn't apply to his case. So let's do one more. Bronwyn, an extended job overseas. Facts: Bronwyn, an Australian resident, has received a job offer to work overseas for 3 years, with the option to extend for another 3 years. Bronwyn, her husband, and 3 children decide to make the move. They retain their property in Australia as they intend to return one day. The house will be rented out during their absence. Bronwyn is uncertain whether she will extend the option to stay after 3 years and will decide later, depending on how the family like the life there. While overseas, they will rent a house with the accommodation allowance provided under her contract. Is this a case of a foreign resident or an Australian resident? What is your guess? Foreign resident. Okay, let's go through the reasons why. The residency test, the resides test. This test is not satisfied because the length of Bronwyn's physical absence from Australia and the surrounding circumstances, such as establishing a home overseas with her family and renting out her family home in Australia, are not consistent with residing in Australia, even though she has retained the family home in Australia. So notice that, that's quite interesting, right? Retained a home, but wasn't considered resident. And this is consistent with the earlier one in the opposite direction with respect to the person who kept the house in UK. The domicile test. Her permanent place of abode is outside Australia due to the length of time she is committed to spending overseas. So interesting, right? 3+ years. Establishment of a home overseas, and her family accompanying her. Okay, so those are factors they looked at. The fact that she will not be selling the home in Australia, although relevant, is not persuasive enough to overcome the finding on the basis of the other factors. It is arguable that she has abandoned her home in Australia for the duration of her stay by renting it out. She doesn't stay in the country 183 days, so that test is not an issue. And the superannuation test also doesn't apply. We'll do one more. Janine, combining work and travel. Janine is a British national who has longed to spend 12 months down under. After saving for years, she takes 12 months leave from her home and departs for Australia on her 24th birthday. Although she travels with considerable savings, her intention is to spend at least part of her time working. She has obtained a working holiday visa, enabling her to work for no more than 6 months with one employer. Through a contract in Australia, she is assured of work in Perth for the first 3 months. After that period, she decides to travel to the East Coast via Adelaide. She spends a month in Adelaide where she works for 2 weeks and continues her journey to Melbourne. Once there, she meets some friends from back home. After working for a further 3 months, she decides to spend the balance of her time in Melbourne and uses her savings for living expenses. To keep costs down, she leases a house with 2 other friends. At the end of her 12 months in Australia, she returns to the United Kingdom and resumes living in her house there, which she has been renting out while in Australia. So, is she foreign citizen or a local citizen? So she's foreign in this particular case. And I think that one is probably much more relevant. So or not much more relevant, but much easier to understand. So the point is, in these examples, the amount of time spent in a country did not dictate whether the person was a local or a foreigner, right? Literally, you had a case where somebody was physically in a country for longer than that time. Now, there's a subtlety in here that I didn't cover in this video, and I'll maybe cover in some others, which is in some cases, under certain visas, you can actually spend more than 12 months in a country, and definitely more than 183 days, and not be considered tax resident there because of other facts related to that visa. So the treatment of that visa can matter. So this is an example of that, right? In the country for over 12 months, but not considered to be a local resident because of that. So anyway, I hope that gives you some idea of how time is not necessarily the issue, facts are the issue, and this can kind of like swing. And one of the key defining factors is, do you demonstrate the intent to leave one place permanently or reside in another place permanently, okay? That's like a very, very key thing. Now, permanently doesn't necessarily have to mean forever, but it's like you're going there and you're making that your home at least for a period of time, and maybe in the future you will change that, but for now that's the case. So I hope that helps. If you have questions about it, put it in the comments below. If you like the video, give it a thumbs up. Really appreciate the support. If you have questions about these topics, or you'd like help with relocating, with getting a citizenship, with, like I said, international tax planning or whatever, please reach out to me. You can book a call, calendly.com/Michael-Rosmer, link in the description below, or check out our websites, offshorecitizen.net, offshorecapitalist.com, and send us a message through there. I will see you guys on the next video.